43 seconds of silence before Miriam Cole said her first word. The Supreme Court of the United States. 9 justices. Both hands on the mahogany lectern, breathing steady. At the respondents' table, 4 attorneys for the city of Columbus, collectively billing more per hour than Miriam had earned in her first year at the housing department, none of them looking up from their notes. In the gallery sat 3 lawyers who had each reviewed her case and turned her away. They had all come to watch. Not one of them had expected to watch this. Rewind 22 years. To a cold Monday morning in March, when Miriam Cole walked into the Columbus Department of Housing Services carrying a leather portfolio her mother had given her as a graduation gift, and quietly decided to be the best person in the building. She was 28. She held a political science degree from Ohio State and a paralegal certificate earned nights and weekends while working as a legal secretary at a civil rights firm downtown, a place that handled fair housing cases, tenant rights claims, and employment discrimination. The full catalog of ways institutions refuse people what they are owed. She had spent 2 years there after college, and in those 2 years she had learned something foundational about how law actually functioned. It rewarded documentation, specificity, and patience. She had also, in the spring of her senior year, been accepted to the University of Michigan Law School. The acceptance letter arrived on a Thursday. Her mother's cancer diagnosis arrived on a Sunday. She deferred her enrollment, kept working, watched her mother recover slowly over 2 years, and at some point the window on law school closed without a formal decision ever being made. Life had simply arranged itself differently. She filed the letter in a box. She moved forward. She was exceptionally good at moving forward. That was the thing about Miriam Cole that her colleagues recognized within weeks of her arrival at the housing department. A quality of focused purposefulness that looked like ambition from a distance, but was actually something more patient than that. She cared about the families she served. The elderly tenants facing eviction. The young parents navigating housing assistance applications for the first time. The clients who arrived in her office carrying everything they owned in bags from the grocery store. She stayed late because the work required staying late. She built expertise because the work required expertise. And every year, when performance reviews came around, her supervisors documented what the numbers already showed. Miriam Cole was running the highest volume caseload in the Southeast District, 12 points above departmental average in client outcomes, with 0 formal complaints, and a training record that 3 successive directors had relied on without ever formally acknowledging. She applied for the senior case manager position the first time in 2011. She was told the selected candidate had stronger supervisory experience. He was white. He had been with the department 4 years compared to her 10. She applied again in 2013 and again in 2015. She was passed over both times for reasons she was never given the full opportunity to discuss. By 2016, she had stopped applying and started watching. Kevin Drescher arrived in January 2016 as the new department director, transferred from a suburban county administrator's office with an easy handshake and a presentation about organizational alignment. Miriam noticed things about Drescher within the first month, not the dramatic signals, not the slurs or explicit exclusions, but the quieter ones. The staff meeting where he went around the table asking for introductions and paused a beat too long at hers, as if recalibrating. The project distribution email that copied everyone except her, then added her name when another supervisor pointed it out. The department photo in the lobby where the caption identified every person in the front row except the one with the most tenure. Small things, each one explainable on its own. Collectively, something else entirely. In March, Drescher promoted Dale Ferris to senior case manager. Dale had 4 years at the department. He carried 3 performance improvement notices in his personnel file, On the official evaluation rubric used to assess the 6 candidates, Miriam had ranked first in every category. The decision came to her by email. Brief, professional, citing organizational fit as the basis for the selection. She read the phrase twice. She printed the email. She opened a blank notebook, wrote the date at the top of the first page, and started keeping records. For 14 months, she documented everything. Professional development funds approved for every colleague who applied, denied to her without written justification. A client retention report she had authored presented to the director without attribution. A team leadership role assigned to Dale Ferris for a project Miriam had been running independently for 11 months. And in her November performance review, a note from Dracher indicating she struggled to adapt to departmental changes. An assessment so disconnected from her objective metrics that she read it in his office and told him, quietly and directly, that she would like that characterization on record so she could respond to it formally. He told her to take some time before responding. She left his office and added that exchange to the notebook, including the exact time, 3:18 p.m. In April 2017, she filed a formal grievance with the city's Human Resources Office. The city investigated itself for 11 weeks and found no evidence of discrimination. In May, Miriam walked into her first law office. James Whitmore's firm occupied the 15th floor of a building on High Street. Marble in the elevator lobby, framed portraits of founding partners in the corridor, a waiting area that smelled faintly of old oak and leather. He was 58, silver-haired, 26 years in employment law. The kind of man whose handshake carries the full weight of his ursum. He took the meeting himself. His assistant had told Miriam it would be 45 minutes. It was 22. Whitmore opened the folder, reviewed the first 2 tabs, and then looked sideways at his associate, a younger man who had come in to take notes, with the particular expression of a man who has priced a case before the presentation is finished. It was not quite a laugh, but it was the cousin of one. A brief exhale through the nose, a slight compression of the lips, the controlled amusement of someone who has seen this version of the file before and already knows how it ends. He closed the folder. He told her, politely and with practiced courtesy, that she had no direct evidence of discriminatory intent, that each incident carried a facially neutral explanation, that the HR finding would be used against her at every stage, that the city's legal department was well-resourced, that his firm couldn't responsibly represent her in this matter. He shook her hand. His assistant walked her to the elevator. Miriam rode down 15 floors with the folder in both arms. She didn't speak to anyone in the lobby. She walked to her car. She drove to the library. Sandra Reeves had practiced employment discrimination law for 11 years out of a firm she'd built herself on the east side of Columbus. She was 44, precise, the kind of attorney who memorized case names the way other people memorize songs. She was also black, which was part of why Miriam had made the drive across town. Sandra listened for 37 minutes, which felt meaningfully different from 22. Then she gave the same answer. The pattern was documented, Sandra said, but pattern evidence alone rarely survived summary judgment in this circuit without a clear comparator, someone who received demonstrably different treatment under demonstrably similar circumstances. The HR finding created structural headwind. The defense team would have unlimited billable hours, and Miriam would have herself, and that asymmetry was not abstract. She offered Miriam something concrete instead. A negotiated severance, a clean departure, financial breathing room, handled in 90 days. She said it with genuine warmth. She meant it as the practical thing, the realistic thing, The thing that would protect Miriam from pouring years of her life into a case and receiving nothing on the other side. Miriam thanked her. She drove home. She updated the notebook. Thomas Park had spent a career winning the cases that people said couldn't be won. His organization had challenged redlining in 3 Ohio counties, litigated lending discrimination affecting 40,000 borrowers, argued a school resource allocation case that changed how Ohio assessed educational equity. He met with Miriam on a Thursday afternoon in a conference room where the whiteboard still held diagrams from that morning's staff meeting. Evidence of an organization stretched across work that mattered. He listened. He read through the documentation more carefully than either of the others had. And then, Miriam outlined the legal theory. She had spent months developing it. The argument that Title VII's hostile work environment standard required courts to evaluate the totality of documented discriminatory conduct rather than each incident in isolation. That discrimination doesn't operate through a single catastrophic event. It operates through accumulation, through 100 small compressions over 1,000 days, none of which clears a legal threshold on its own, all of which together make a professional life impossible. The courts had been systematically miscounting it. The statute didn't require that view. She had the case law. Thomas Park smiled, just for a moment, a brief, involuntary smile, the reflex of a man who has been practicing civil rights law for 20 years and has heard ambitious legal arguments constructed by people who were not lawyers. He caught it before it became a laugh. But it had been close enough, and Miriam saw it, and in the fraction of a second before Park's professional courtesy reasserted itself, she understood exactly what the smile meant. Creative argument, he was thinking. Sympathetic client. Not a real case. He said his organization worked on systemic claims, not individual employment disputes. He suggested the EOC. He suggested a regional legal aid organization. He stood and shook her hand. Miriam Cole walked down the stairs to the sidewalk. She stood outside for a moment in the afternoon heat, with her folder under one arm. She thought about the smile. She thought about 22 minutes and 37 minutes, and the way 3 different rooms had shown her the same door. Then, she went home, sat at her kitchen table with the notebook, and decided she was going to file the case herself. She filed pro se, for herself without an attorney, in the Southern District of Ohio Federal Court. The clerk processed the paperwork and asked twice, gently, whether she understood the filing. Miriam said she understood. Over the following 8 months, she read every Title VII hostile work environment case decided by the Sixth Circuit in the prior 15 years. She worked at the Ohio State Law Library 3 evenings a week, and every Saturday morning. She cross-referenced circuit splits, tracked how courts had drawn the line between actionable pattern evidence and isolated incidents, and mapped the exact gap in the existing doctrine, the place where the law, as courts had been applying it, required discrimination to announce itself clearly rather than revealing itself cumulatively. Her theory was not a layperson's misreading of the statute. It was a precise legal argument about a genuine doctrinal inconsistency that no circuit had squarely resolved. She had found it, and she intended to make a federal court sit with it. The district court granted summary judgment for the city. The judge's opinion acknowledged, in a footnote on page 38, that the cumulative picture in Miriam's documentation was troubling. Footnotes don't protect workers. She read the opinion the day it arrived, filed her notice of appeal the same afternoon, and called an attorney at Ohio State's Civil Rights Law Clinic who had quietly been following the proceedings. Here is where the case stopped being just hers. The Sixth Circuit scheduled oral argument. A 3-judge panel received her 61-page prose brief, sourced structured, and argued with a precision that courthouse observers noted was unusual for unrepresented litigants, which was a diplomatic way of saying it was unusual for anyone. The panel treated it as what it was: serious legal work. Judge Patricia Holloway wrote the reversal. It was 23 pages, and it moved through the doctrine with clarity. Evaluating discriminatory workplace conduct incident by incident, Holloway wrote, missed the fundamental nature of how workplace discrimination actually operates. Each of the acts Miriam documented, viewed in isolation, might be dismissed as ambiguous. Together, across 14 months of dated and cross-referenced entries, they constituted a sustained campaign against one person's professional existence. Title VII was built for exactly this, but only if courts were willing to count correctly. The cumulative harm doctrine, the opinion concluded, was not a novel legal invention. It was a correction. The Sixth Circuit reversed. The City of Columbus appealed. The Supreme Court granted certiorari. The legal press ran it immediately. A circuit split had been developing quietly across 3 circuits for years. Cole v. Columbus was the vehicle the court had been waiting for. 3 law reviews requested interviews. A Washington civil rights firm, Caldwell and Osai, offered full pro bono representation for the Supreme Court proceeding. Miriam accepted on one condition: she would argue. Their lead attorney, Amara Osei, would handle the statutory construction questions. Miriam would argue the doctrine itself. Amara agreed without hesitation. Now consider the positions of the 3 lawyers who had each looked at this case and found it lacking. James Whitmore had been retained months earlier as a consultant to the City of Columbus's defense team, brought in for his employment law background, his Sixth Circuit experience, his knowledge of the existing precedent. He would sit at the respondent's table. He would be in the room, arguing against her. Sandra Reeves had followed the case through the legal press with a feeling she couldn't quite name. Admiration, yes, but also the particular discomfort of having been wrong in a way that genuinely mattered. She arranged for a gallery seat. She sat in the front row. Thomas Park brought 6 students from his civil rights law clinic. He had been teaching the case all semester. The week before argument, he told his students plainly, "The woman who filed this case sat in my office and explained this exact theory to me, and I smiled." He wanted them to see what the smile had cost. On October 14th, Miriam Cole arrived at 1 First Street NE before 7 in the morning. The Supreme Court building was still catching the first light of the day, its white marble columns cold and enormous in the gray air. She stood outside for 2 minutes, not from nerves. She had read the briefs and the responses and the amicus filings 43 times. She had rehearsed every line of her opening until the words arrived not from memory, but from conviction. She stood outside because she wanted to hold the moment a little longer before it became the past. The argument lasted 62 minutes. She stood at the lectern for 38 of them. The justices pressed her from every direction on workability. How would lower courts set the threshold for cumulative harm claims? What shielded employers from cases assembled from trivialities? Hadn't Congress drawn specific limits on Title VII's reach? She answered each question directly and without retreat. When Justice Kemp pressed her hardest, suggesting that her reading of the statute would expose virtually any unpleasant workplace to a federal hostile work environment claim, she paused. 2 full seconds of silence in the chamber of the highest court in the country. The gallery went completely still. Then she said, "The statute was designed to protect workers from discrimination, not to protect employers from the paper trail that discrimination leaves behind. Any limiting principle was already present in the statute's own language, the requirement of conduct that is severe or pervasive. The only question was whether courts were willing to count all of it." 3 justices leaned forward at exactly the same moment. James Whitmore, 40 feet away at the respondent's table, had not looked up from his notes in 11 minutes. In the gallery's front row, Sandra Reeves had stopped writing. Thomas Park, 12 rows back, sat with both hands flat on his knees. The 6 students beside him were watching in complete silence. The court issued its ruling 11 weeks later, 6-3. The majority opinion adopted the cumulative harm doctrine as a matter of federal law under Title VII. Courts must evaluate the totality of documented discriminatory workplace conduct in assessing hostile work environment claims, not the severity of individual incidents assessed in isolation. The opinion cited Miriam's compiled documentation 18 times. It reversed the original summary judgment. It remanded for trial. The city of Columbus settled before the case returned to district court. The amount was sealed. Employment attorneys across 12 circuits began citing Cole v. Columbus within weeks of the opinion. Legal aid organizations reported a measurable increase in workers reaching out with cumulative harm claims they had previously been told weren't actionable. Ohio State added the case to its first-year employment law curriculum before the semester turned. Sandra Reeves emailed Miriam 3 weeks after the ruling. She said she had been wrong, plainly and without hedging. She said she had sat in the gallery watching the argument and felt at several points the way she imagined she should feel in a courtroom but rarely did anymore, as if she were watching the law do exactly what it was supposed to do. She asked if Miriam would speak to her students. Miriam said yes. Thomas Park's clinic published a 30-page practice guide on cumulative harm claims, distributed free to legal aid organizations in 7 states. His cover note said the case had come through his office. He wrote that he had declined to take it. He did not explain the smile. He didn't need to. Miriam Cole enrolled at Ohio State Moritz College of Law that fall. She was 47 years old. She sat near the back of her first orientation session and listened to a professor describe the evolution of employment discrimination doctrine. When the professor mentioned that the cumulative harm standard was a relatively recent development in the Sixth Circuit, significant, unsettled, still working through the lower courts, Miriam raised her hand. She said she was familiar with that case. The professor looked at her for a moment, then looked again at the name on the roster, then said, simply, "This class is going to benefit from having you here." In her apartment, on the back of her bedroom door, the navy suit hung on its wooden hanger. On her desk sat the leather portfolio her mother had given her decades ago, the same one she had carried into James Whitmore's office, and Sandra Reeves's office, and Thomas Park's office, and the federal courthouse clerk's window, and the library on Saturday mornings, and the lectern of the Supreme Court of the United States. Inside it, the notebook. Every page filled. In a box in the closet, untouched, the law school acceptance letter from Michigan. She hadn't needed it. She had built something better than a credential. She had built a case, and she had carried it herself, all the way to the room where it changed what the law meant for everyone who came after her.